Imagine a state detects through AI processed signals intelligence that an adversary's autonomous weapons systems have been activated and are 12 minutes from striking its critical infrastructure. No human commander has issued an order. No declaration of hostilities have been made. The algorithm on the other side has made a decision. Does the target state have the right to strike first, right now, before a single weapon crosses its border? It might sound like a scenario from speculative fiction. The operational architecture that makes it real has already been deployed across multiple active theaters. This is the self-defense problem. And in the age of autonomous weapons, AI-processed threat intelligence, and subhuman decision timelines, it is no longer a theoretical problem. It is the central legal fault line of contemporary conflict. Because the right of self-defense under Article 51 of the UN Charter was written for a world where human beings made decisions at human speed. That world no longer exists. I'm Nupur Mitra, a techno-legal analyst, and in this episode of the Algorithmic Warfare series, I'm going to guide you through a precise legal analysis of self-defense, its triggers, its limits, and the specific ways in which the AI and autonomous weapons architecture of modern conflict is systematically dissolving the doctrinal foundations on which the right to self-defense was built. This is not a summary of Article 51. It is an expert analysis of what Article 51 actually requires, what the operational record reveals about how it is being invoked, and what the legal consequences are when the decision to use force in self-defense is made or pre-authorized by a system rather than a commander. Expect precise engagement with the law of imminence, necessity, proportionality, non-state actors, collective self-defense, and the accountability structures that collapse when AI enters the self-defense decision chain. Question 1. What triggers the right to self-defense under Article 51? Article 51 of the UN Charter provides that nothing in the Charter shall impair the inherent right of individual or collective self-defense if an armed attack occurs against a member of the United Nations. That phrase, if an armed attack occurs, is the threshold condition on which the entire right depends. The International Court of Justice in the Nicaragua case established the foundational distinction between the most grave forms of the use of force, those constituting armed attacks, and less grave forms which may warrant countermeasures but do not trigger the Article 51 right. An armed attack on the Nicaragua standard requires a scale and effects assessment. Not every cross-border use of force constitutes an armed attack for the purposes of Article 51. The AI dimension begins precisely here. When an autonomous drone system crosses a sovereign border and strikes a military installation without a human operator initiating that specific strike, does the armed attack that triggers Article 51 occur at the moment of impact, at the moment of deployment authorization, or at the moment of the targeting algorithm that was pre-authorized to execute strikes within defined operational parameters? The answer to that question determines when the self-defense right activates, who bears responsibility for the attack that triggered it, and whether the state deploying the autonomous systems can claim that no armed attack was formally ordered by a human commander. The temporal and causal disaggregation that autonomous systems introduce into the armed attack threshold is not a technical problem. It is a legal problem of the first order because Article 51's entire accountability structure assumes a human decision maker who can be identified, attributed, and held responsible for the act that triggers the right to respond. When the trigger is an algorithm's output, that assumption fails. Question 2. Can anticipatory self-defense be legally justified? The text of Article 51, if an armed attack occurs, is grammatically clear. The armed attack must have occurred before the self-defense right activates. The charter drafters writing in 1945 designed a system that required actual attack before force could be used in response. The doctrine of anticipatory self-defense, the claim that a state may use force before an armed attack occurs when that attack is sufficiently imminent, is not expressed in the charter text. It derives from customary international law, specifically from the Caroline formula articulated by U.S. Secretary of State Daniel Webster in 1837, which holds that the necessity of self-defense must be instant, overwhelming, leaving no choice of means and no moment for deliberation. The Caroline standard has never been formally incorporated into the charter framework. States invoking anticipatory self-defense operate in a zone of legal contestation, with one group of states, including the United States and its treaty allies, maintaining that Article 51 preserves the customary right of anticipatory self-defense, and another group, including a substantial bloc of states in the global south, maintaining that Article 51's if an armed attack occurs language forecloses anticipatory action and that any pre-attack use of force violates Article 2, Clause 4. The AI architecture of contemporary conflict makes this doctrinal dispute existential. An AI-processed threat assessment that identifies an incoming autonomous weapon strike 12 minutes before impact is not the same legal situation as a human intelligence officer reporting that an adversary is massing troops on the border. The AI assessment may be wrong. The algorithm may have misclassified a civilian aircraft as a weapons system or misinterpreted a training exercise as an operational launch. The decision to strike in anticipatory self-defense based on that AI assessment, if it turns out to be incorrect, produces a use of force against a state that had not, in fact, committed an armed attack. Under Article 2, Clause 4, that use of force is itself a violation, and the anticipatory self-defense justification fails. The reliability, interpretability, and auditability of the AI threat assessment system is therefore not a technical specification. It is a legal prerequisite for the lawfulness of anticipatory self-defense in an AI-enabled threat environment. Question 3. What constitutes imminence in the context of AI-driven threats? Imminence is the temporal core of the self-defense analysis. Under both the Caroline Standard and its modern formulations, including the 2004 UN High-Level Panel on Threats, Challenges and Change, and the 2005 World Summit Outcome Document, the threat must be sufficiently imminent that waiting for the attack to materialize would forfeit any meaningful ability to defend. In a human-paced conflict environment, imminence had an intuitive quality. Troops crossing a border, aircraft entering sovereign airspace, missiles launched on radar. Decision timelines were measured in hours or days. The deliberate process that international law expects, the Security Council notification requirement under Article 51, the necessity assessment, the proportionality analysis, could in principle occur before force was used in response. The AI and autonomous weapons environment compresses every element of that analysis to timescales at which human deliberation is operationally impossible. An autonomous hypersonic weapons system has a strike timeline measured in minutes. A cyber operation designed to disable critical infrastructure, power grids, communication systems, air defense networks can achieve its objectives in seconds. An AI-enabled electronic warfare system can degrade satellite navigation infrastructure across an entire operational theater before a human commander at the targeted state has received, processed, reported the initial alert. In that environment, what does imminence mean legally? Does it mean that the automated response systems of the targeted state are pre-authorized to respond at AI speed before any human has assessed necessity or proportionality? If so, the legal requirement of human deliberation that underpins the self-defense framework has been effectively pre-delegated to an algorithm, and if the pre-authorized response turns out to have been triggered by a false positive, an AI threat assessment error, the use of force it produces is not lawful self-defense. It is an unprovoked attack on a state that had committed no armed attack. The legal framework has not resolved this. The imminence requirement, as currently understood, is incompatible with the decision timelines of autonomous weapons systems. Either the law adapts to define imminence in AI speed conflict environments with specific standards for human authorization, algorithmic reliability, and accountability for AI-triggered responses, or states will continue to pre-authorize AI systems to make self-defense determinations in real time outside the legal framework entirely. Question 4. Does continuous threat justify continuous defense? The doctrine of continuous self-defense, the argument that a persistent ongoing threat authorizes a continuous defensive military campaign without a fresh Article 51 assessment for each use of force, has been invoked repeatedly in contemporary conflicts to justify extended military operations against non-state actors operating across multiple sovereign territories. The legal validity of continuous self-defense has never been authoritatively affirmed by the ICJ or the Security Council. States invoking it rely on a policy argument that requiring fresh legal justification for each individual strike in a sustained campaign against a persistent threat is operationally impractical. The law's response, implicit in the structure of Article 51, is that the necessity and proportionality analysis must attach to each use of force, not merely to the initial decision to engage. The AI architecture of continuous operations makes this legal tension acute. When autonomous systems are deployed on persistent surveillance and strike authority, maintaining continuous targeting coverage over a defined operational area and executing strikes against identified targets within pre-authorized parameters, the legal question is not whether the initial deployment was justified under Article 51. It is whether each individual strike authorized by the system satisfies the necessity and proportionality requirements that Article 51 and Additional Protocol 1 jointly impose on every individual use of force. An algorithm operating on persistent pre-authorization does not conduct that analysis for each strike. It applies its objective function. The legal requirements and the operational architecture are in direct conflict, and in that conflict, it is the legal requirements that are being silently displaced. Question 5. Can self-defense extend to non-state actors operating from another state? The Nicaragua case established that the right of self-defense under Article 51 is triggered by an armed attack attributable to a state. Non-state actors, armed groups, terrorist organizations, proxy forces, autonomous cells are not in their own right subjects of international law capable of committing the state act that Article 51 addresses. The post-2001 practice of states has substantially eroded that baseline. The unwilling or unable doctrine, the argument that a state hosting or tolerating non-state actors who conduct armed attacks against another state forfeits its sovereignty protection and becomes a lawful target of self-defense action has been invoked repeatedly across multiple conflict contexts. The doctrine has no express basis in the Charter text and no authoritative endorsement from the ICJ. It has been consistently contested by a significant block of states as incompatible with the sovereign equality principle of Article 2, Clause 1. The AI dimension restructures this debate. Proxy non-state actors that are increasingly operating autonomous weapons systems, drones, maritime autonomous systems, AI-enabled electronic warfare platforms, supplied, trained, remotely operated with state-level technical infrastructure. When an autonomous drone system attributed to a non-state actor strikes a target across sovereign border, and when the AI targeting architecture of that system was designed, trained, remotely monitored by a state party, the attribution analysis under the Nicaragua Effective Control Standard and the TADIC Overall Control Standard must penetrate the non-state actor layer and reach the state infrastructure behind it. The AI supply chain, the training data, the command and control architecture, the satellite uplink, the software update pathway is the evidentiary record of state involvement, and it is increasingly the primary basis on which Article 51 self-defense against the supporting state will be asserted and contested. Question 6. When does self-defense violate the sovereignty of third states? Self-defense operations conducted across sovereign borders, whether targeting non-state actors, infrastructure supporting adversary operations, or command and control nodes, require legal justification under both Article 51 and the territorial sovereignty principle of Article 2, Clause 1. The state whose territory is used must either consent to the operation, be willing or unable to prevent the threat emanating from its territory under the contested doctrine discussed earlier, or itself be the aggressor. Third states, states that are neither the target nor the object of self-defense operations, but whose territory, airspace, or infrastructure is used or affected, occupy a particularly complex legal position. A state that grants overflight rights for self-defense operations is not, on that basis alone, a co-belligerent. A state whose territory is used without consent as a staging ground or transit corridor for autonomous weapons systems, where the AI-enabled platforms, they transit sovereign airspace without human operator presence and without diplomatic clearance, raises a different legal question. The unauthorized transit of sovereign airspace by an autonomous weapons system is a sovereignty violation under international law, regardless of the self-defense justification offered for the mission it is conducting. The extraterritorial reach of AI-enabled self-defense operations, the ability to project autonomous striking capacity across multiple sovereign territories without human operator presence in any of them, means that the sovereignty implications of a self-defense campaign are now geographically diffuse in ways that the legal framework was not designed to address. Question 7. Is collective self-defense unlimited in scope? Article 51 preserves the right of both individual and collective self-defense. Collective self-defense, the right of states to assist a state that has suffered an armed attack, is the legal foundation of collective security arrangements, including NATO's Article 5 and bilateral mutual defense treaties. The Nicaragua case established two conditions for lawful collective self-defense. The state under attack must have declared itself to have been attacked, and it must have requested assistance from the state proposing to exercise collective self-defense on its behalf. Without both elements, declaration, request, collective self-defense is not lawful under Nicaragua standard. The AI dimension of collective self-defense introduces a category of assistance that the Nicaragua framework did not contemplate: the provision of AI-processed targeting intelligence, autonomous weapons systems, AI-enabled electronic warfare capabilities, or AI-trained targeting algorithms to a state conducting active self-defense operations. A state that provides real-time AI-processed targeting data to another state conducting strikes against an adversary is not deploying its own forces. It is not formally a co-belligerent, but its contribution to the targeting decisions that produce the use of force, if the AI system it provides is integral to the strike authorization process, makes the legal characterization of its role as a neutral provider of technical assistance increasingly difficult to sustain. The scope of collective self-defense in the AI era is therefore not limited by geography or force deployment. It is limited, or more precisely, it is failing to be limited, by the invisibility of the AI infrastructure through which collective participation in the use of force is channeled. Question 8. Can self-defense justify actions against indirect supporters of an adversary? The question of indirect support. States that provide financial assistance, intelligence sharing, diplomatic cover, dual-use technology to an adversary without directly participating in hostilities has been contested in every major conflict of the past 3 decades. The Nicaragua case was itself a case about indirect support. The court found that US assistance to the Contras did not meet the effective control threshold for attribution of their acts to the United States. The AI infrastructure of indirect support has made the evidentiary and legal analysis significantly more complex. A state that provides AI training data sets to an adversary's weapons development program, or that supplies AI chips whose processing capacity enables autonomous targeting systems, or that provides satellite imagery that feeds an AI targeting algorithm, is providing support whose connection to the use of force is technically mediated, causally extended, and legally contested. Under Article 16 of the ILC Articles on State Responsibility, a state that aids or assists another state in the commission of an internationally wrongful act is internationally responsible if it does so with knowledge of the circumstances of the internationally wrongful act. The knowledge standard. Does the providing state know that the AI capability it supplies will be used in an operation that constitutes an internationally wrongful act? Is the legal question on which indirect support liability now turns. And in the AI context, that question is not merely factual, it is architectural. What does the design of the system and the documented record of the operations it enables collectively establish about what the providing state knew and when it knew it? Question 9. How does necessity and proportionality apply in technologically advanced warfare? Necessity and proportionality are the twin operational constraints on lawful self-defense. Necessity requires that the use of force be indispensable to repel the armed attack, that no non-forcible means were available to achieve the same defensive purpose. Proportionality requires that the force used not exceed what is necessary to repel the attack. It is measured against the defensive purpose, not the scale of the original attack. In technologically advanced warfare, both constraints are under structural pressure. AI-enabled surveillance, cyber capabilities, electronic warfare offer states non-kinetic tools for disrupting adversary operations, tools that the necessity requirement arguably mandates be considered before kinetic force is employed. A state that bypasses available non-kinetic options and proceeds directly to kinetic self-defense without demonstrating that non-kinetic means were inadequate may be acting in violation of the necessity requirement, even if the underlying armed attack was real. The proportionality constraint is equally stressed. Precision strike capabilities enabled by AI targeting systems theoretically allow states to calibrate force with greater accuracy. But the same AI targeting architecture that enables precision can also enable scale. Autonomous systems can execute far greater numbers of strikes in a given operational period than human-operated systems, expanding the aggregate effects of a self-defense campaign beyond what proportionality permits. Precision at the individual strike level does not resolve disproportionality at the campaign level. And the proportionality assessment at campaign level, whether the cumulative effects of a sustained AI-enabled self-defense campaign exceed what is necessary to repel the original attack, is a legal question that no court has been required to answer in the context of autonomous systems. Question 10. Can AI-assisted targeting alter proportionality assessments? The proportionality assessment under Additional Protocol 1, Article 51, Clause 5, Subclause B requires a commander to weigh the expected incidental loss of civilian life and damage to civilian objects against the anticipated military advantage. It is, at its doctrinal core, a human judgment, the exercise of a military commander's trained assessment of competing values, conducted in the context of a specific operational situation, with knowledge of the specific target and its surrounding environment. AI-assisted targeting systems alter that assessment in two structurally distinct ways. The first is epistemic. An AI targeting system may provide a commander with more accurate intelligence about a target, its precise location, its function, its occupants, the blast radius of different munitions, the projected civilian casualty count under different strike parameters. If that intelligence is accurate, it may enable a more precisely calibrated proportionality assessment than a human commander operating on incomplete information could have made. That is the case for AI-assisted targeting that its proponents advance. The second is structural. The same AI system may compress the time available for proportionality assessment to the point where meaningful human deliberation is operationally impossible. When targeting decisions are made at machine speed, when the algorithm, it identifies a target, calculates the strike parameters, and presents a human operator with a binary authorization decision on a timeline measured in seconds, the proportionality assessment that international law requires is being conducted in practice by the algorithm. The human authorization is a formal act, not a substantive legal judgment. This is the structural accountability gap that AI-assisted targeting creates in the proportionality framework, and it does not resolve in favor of lawfulness simply because a human pressed a button. Command responsibility under Additional Protocol 1, Articles 86 and 87 requires a commander to have the means to prevent violations, not merely the formal authority to approve strikes. When the operational tempo of AI-assisted targeting systems makes the exercise of that preventive authority functionally impossible, the command responsibility framework and the operational reality of AI-enabled warfare are in direct conflict. Self-defense was built on the assumption that human beings make decisions to use force deliberately, under identifiable legal constraints, with identifiable accountability for the consequences. The AI and autonomous weapons architecture of contemporary conflict is systematically replacing each element of that assumption. The decision is made by a system, the constraint is encoded in an objective function, the accountability is distributed across a design chain, a procurement chain, and a command chain that international law's current frameworks were not built to reach simultaneously. This algorithmic warfare series which you're watching on my channel here, this is episode 3. You must have watched episode 0, 1, 2 as of now, will map that accountability gap with the precision that the operational record demands and the legal consequence it produces. In this episode, we've examined the right of self-defense under Article 51 across its full doctrinal spectrum, from the armed attack threshold that triggers it, through the contested terrain of anticipatory self-defense and continuous operations, to the outer limits of collective self-defense and action against indirect supporters, and into the core proportionality and necessity constraints that govern every use of force it authorizes. At every point in this analysis, the AI and autonomous weapons dimension is not a complication added on top of the existing law. It is a structural challenge to the assumptions that make the existing law function. The threshold conditions, the attribution standards, the imminence analysis, the proportionality assessment, the command responsibility framework, each depends on human decision-making at a defined point in a defined chain. Each is being systematically displaced by AI architectures designed to operate below the threshold of real-time human authority. In episode 4, the next episode to come, we turn to state responsibility and indirect participation, the legal framework governing what happens when states support, enable, or fail to prevent the conduct of others. The questions that framework must now answer: attribution of AI operations, responsibility for algorithmic outputs, the legal significance of supplying AI capabilities to states engaged in internationally wrongful acts, are the questions on which accountability for the next generation of conflict will be built or lost. Follow me on my channel, The AI Law. I'm Nupur Mitra. The law is moving, so are we. See you in my next episode, episode 4.